Okay, parties, the court will find and rule as follows. The question before the court today is whether or not the state has proven by clear and convincing evidence that no release conditions will reasonably protect the safety of any other person or the community. Parties, I see you both taking notes. I'll let you know that I'll prepare the order and it'll be filed by close of business tomorrow. So the question under Rule 5409 is broken down into a three-part analysis as articulated in State versus Groves. And as part of that analysis, the court considers the factors enumerated in 5409 F6. So as to the first question in Groves, I do find that the information provided contains sufficient indicia of reliability to be worthy of consideration and has been duly considered. That consists of the 7 exhibits submitted by the state, the 4 exhibits submitted by defense, as well as the testimony of Detective Griego. As to the next question, or rather the extent to which that information would indicate that a defendant may likely pose a threat to the safety of others if released pending trial, I do find the state has met its burden by clear and convincing evidence based on the following findings. First, the nature and circumstances of the charges indicate that Mr. Peña is alleged to have coordinated a conspiracy to involve drive-by shootings at the homes of 4 different elected officials, which at least conveys an effort to intimidate or threaten the elected officials, but at worst evinces some sort of intent to inflict harm on the elected officials or their family members. So based on the nature and circumstances of the charges, as well as defendant's own history as a convicted felon, and the allegations of possession and use of an assault rifle, as well as the allegation that he has provided firearms to his conspirators, I do find the state has met its burden there. As to the last prong, whether or not there are any potential pretrial release conditions that will reasonably protect the safety of others, I again find that the state has met its burden in proving that there are no release conditions that would reasonably protect the safety of others. First, I incorporate the findings I already made about the nature and circumstances of the offenses charged. As to the weight of the evidence, I'll say this. Based on the digital evidence presented by the state in the criminal complaint, as well as the forensic evidence collected by the Albuquerque Police Department, I do find that there is considerable weight that Mr. Peña has been in control of this conspiracy, and that the weight of the evidence is strong. Now, as to the confidential witness, I also acknowledge that on cross-examination, Ms. Yersick was able to articulate a number of inconsistencies that do trouble the court. However, by and large, the weight of the evidence against this defendant is strong. I'll note that in his criminal history, he's been convicted in 3 separate jury trials of felonies. In those felonies, he was involved in conspiracies regarding property crimes, many of which echo in this present case, in which he's involved in a conspiracy involving stolen vehicles used to accomplish those drive-by shootings. The nature and seriousness of the danger posed to any person or the community that would be posed by the defendants of release is high. The defendant indicated a month-long effort to shoot at the homes of these 4 different elected officials, and there's no indication that that was going to stop. So I do find the defendant poses a specific danger to these elected officials as well as their family members. I acknowledge that the public safety assessment recommends that the defendant should be released with supervision at a level 2, but parties, the public safety assessment is merely a tool. Based on the totality of the evidence presented by the state, I do find by clear and convincing evidence that there are no release conditions that would reasonably protect the safety of this community from Solomon Peña. So parties, I'll take care of the order indicating that he will be held and the state's motion is granted pursuant to 5409. With that, attorneys, is there anything else to address before we adjourn?
Nothing from the state, Your Honor.
Not from defense at this time. Thank you.
Okay, thank you all for your time and we'll be adjourned.